start the recording now. And so I'm just going to say that this is Law's 12065 Foundations of Property Law. And we're covering tonight topic 6 on regulating competing property interests in land under the general law, legal and equitable rights, or basically legal and equitable interests. I've used that word rights as opposed to interests because as if you've read through the material, if you've tried to digest it, then you'll be aware that we're not always talking about interests, for example. We get very particular about our designation of what people have and don't have in property law, and they can have an interest, but they can have something less than an interest. And in particular, in equity, they can have something that is referred to as a mere equity. And that becomes a bit more interesting in terms of working out what that exactly means. But I might direct you to something to give you a bit more insight into that as we proceed along through the evening. Just also while we wait for others to see who might join us, I know it's not that I'm expecting necessarily huge numbers because of the timing of the rescheduled class, but I did want to have the chance to offer it prior to the quiz 2, and I had to then a bit restricted by the timing in terms of the shared Zoom license. I did want to offer it a little bit early in the day, but that wasn't possible. So, but it will be, it's being recorded anyway. And the point that I wanted to make was that I've now uploaded the recording for the tutorial, which we had earlier in the week on Tuesday. I'm sorry that's taken a little while, but sometimes it's a bit, takes a while through YouTube, and then I had a few technical issues. But anyway, it's loaded up there now under topic 5 or week 5. Overnight or early in the morning, I will endeavour to load up the further hour of discussion we had on Tuesday, where we discussed assessment and a few general matters that continued on from the tutorial looking at topic 5. Okay. So I'm just going to take down the attendance list for this class. Just before we start too, if there's any general questions or something you want to bring up just before we launch into what we're going to address this evening, that's fine.
I just wanted to let you know that I've got a tutorial on evidence at 7:30, so at some point I'm going to have to switch over. So I'll apologise for that now. Okay, thanks Lisa, and thanks for joining. In any event, given the fact that you've got that other class, it's very challenging doing mine and then going straight into evidence. But thanks for joining for the time that you can. And again, I just apologise for the timing, but this was the best that I could do. And I wanted to have the chance of offering it prior to the second quiz. We've just been really, mucked around this time with the spat of public holidays and so on, and falling exactly on the days when I've scheduled the classes. That wasn't really anticipated when I did that. So. Yeah, no worries. I'll make sure I listen to this one when it's uploaded for the rest of it.
Yeah, please do. All right. Look, it's only 1 minute past 7. We might wait a little bit longer, just a few more minutes. Has anyone got any other general issues or points you want to bring up? Or you're all reveling in the joy of Foundations of Property Law. I'm enthused about that. Let's hope you'll be just as enthused after you see. Sorry, question? Yeah.
Is the mic working now, or?
It is. Can you bring it a bit closer to your mouth, maybe? Is that possible?
It might be. Actually, I might try, while we're doing this, I'll get another one, because this headset one's always been a problem, so I'll change over mics. I'll back soon.
All right, okay. Grant's joined us. Welcome, Grant.
G'day, can you hear me this time?
I can hear you loud and clear, sir.
Fantastic.
That's excellent. That's excellent. That's good. And Michael will be back with us momentarily when he changes headsets.
Okay.
Look, I might just say, by way of introduction, that, you know, tonight's topic, I don't know what people's reaction to this particular topic is, but, you know, it is it's quite an exacting area within the course, and that's the reason I devoted a separate topic to it. And, you know, it's a bit tricky getting a head around the way that the law has evolved in terms of these priority issues. It's really important to remember that what we're looking at here are priority disputes governed under the general law, where even though, you know, there's a couple of the cases that I've asked you to read through actually deal with Torrens title situations, and I know that's hard for you to really get your head fully around that when we haven't done it, but this is part of the chicken and egg problem we have in property law, that choosing what to do first and then what subsequently to do. And historically, you know, the property law has always been, there's been two core courses, and one has dealt with conceptual features with goods, as we have done, and then with various aspects, important aspects of property law that touches on land interests, and it really does touch on land law, but you have to do them, and you can't do everything, you know, in the second course, because that's a very heavy course. And you know, the Torrens system, and, you know, issues like leases and mortgages and covenants and easements and so, and so trying to decide what to do. And very typically the issue about priorities is dealt with in this way. But as you've seen previously, and as you will have seen in the cases in this topic, that it's really, you know, there are ideas there that's hard to get your head fully around them without already having considered other topics that we will look at in detail in land law. One of those, as I've already just indicated, is the nature of the Torrens system and the interests that one gets under the Torrens system through registering title, and what is the nature of the interest, and how is that different to parcels of land or interest in land that are outside the Torrens system. So that's one area. Another area is, and I've tried to, again, select cases and not, you know, cut cases out and so forth that may go too far into areas that we're going to look at later in land law. From time to time, you will have seen that, you know, leases have come up in tonight's class, which is not uncommon in this area of priorities, is that the concept of a mortgage surfaces, and particularly in regard to competing equitable interests. What we often have is we have competing interests of mortgagees, and that's in the AG-CQ case, very interesting. AG-CQ, of course, CQ, Central Queensland. And that is a Queensland decision, but an important one in further strengthening our understanding of this area of priorities. But the point is that, you know, how can you fully grasp what's going on until you've actually, you know, gone through and understood mortgages? And again, there's a difference in terms of mortgages between a Torrens title mortgage and a general law mortgage. So, for example, just as I say, just before we get on to the tutorial problems, the very first case that comes up in this area of priorities in terms of a prior equitable interest against a subsequent legal interest, the case of Pilcher and Rawlins, which is an early English decision, an 1872 English decision. And some of these cases are earlier English decisions. We can't get away from that. Some of the rules and the approaches were set down in these cases, and they've just carried through, and they're still relevant today. But the point is that you can't really fully grasp what's going on there unless firstly you understand the nature of what a mortgage is, and then second, you understand that there's a difference between a general law mortgage and a Torrens title mortgage. And you might have been, if you've read through Pilcher's case and the facts, and some of these cases as well, the facts get a bit complicated. And that's why in my notes I've encouraged you to construct a diagram and a timeline, very helpful in unpacking the facts within the context of property law cases. But in Pilcher's case, you've actually got the situation, because look at the date, it's 1872 and it's England, there was no Torrens system. So we're looking at a general law mortgage. And the type, what transpires in a general law mortgage is that when the mortgage is taken out or effected, there is a conveyance of the interest in the land to the mortgage, from the mortgagor to the mortgagee, whereby the mortgagee effectively gets the legal interest in the land for the duration of the mortgage. Now that is dramatically different to the circumstance of Torrens title mortgages, which are, the bulk of, because 95%, if not more, of land in this country, in Queensland and in Australia generally, are governed by the legislation that defines and sets the framework for the Torrens title system. So that's why in the Pilcher case, for example, there is discussion about the transfer of the interest and then the conveyance and the reconveyance, and you might have got a bit confused with all that. What's actually happening is that the legal interest gets conveyed, to use that land transaction nomenclature, but is transferred, if you like, to the mortgagee for the duration of the mortgage. And then over time, what evolved, and certainly by 1872 this was the case, but earlier it wasn't the case, but by 1872 in England was the case, that the mortgagor, the original landowner, the original holder of the legal interest of the property, had a right to require the mortgagee to reconvey the property back to them on fulfilment of obligations of the mortgage and paying out of the mortgage. And that was called an equity of redemption, which a court of equity would enforce. Now, all of this is only of, today, one might say, almost of only historical interest. I say almost because there is still that residual percentage of properties in Australia governed by general law, not by Torrens title. And I had the privilege or the burden when I was in practice to be offered up a general law conveyance with mortgage attached. And we had to go through the entire process, and it was fun and games. In addition to which, the client, or my partner, I think at the time, probably not necessarily at the urging of the client, but the partner more so than the client, said, Michael, I think we'll also institute a primary application to bring this land under the Torrens system at the same time. Thank you very much. So it was like Everest. I felt like one of the Sherpas, being hit by the avalanche, in terms of general law conveyancing on the one hand, and then bringing old system title under the Torrens system in New South Wales as it was for the first time. So it was a very interesting experience. And I've still got some of those documents, and I'm going to share them with people that are doing land law next term. So be that as it may, by way of some historical background and context, the point is that it is a bit challenging, I know, from time to time, trying to get your head around the factual matrices or the matrix of these cases. But it is really important, in my view, really important for you to struggle through this process, because that's how you come to terms with understanding how the courts have evolved the rules and principles as they have from the factual situations. You can go away to a textbook and you can read the positive principles stated there with, in parentheses, case at the end, parentheses, case at the end, with no awareness of how on earth these framework of principles have evolved and how the law has come to terms with them. And you've just got to do the hard yards, you know, and then you certainly can go to these other sources to get some clarification, get some reinforcement, put a bit of a spotlight on the areas we need to concern ourselves with. But you've got to try and work through the case law in the first instance. All right. So tonight, as I said, the topic at hand is basically this idea of priorities. A long title there in the topic, but basically priorities between different types of interests that property law recognises. And we're basically looking at three situations in terms of what we're considering. And as I emphasised to you, this is in respect to the general law, not Torrens title. We're looking at, firstly, prior equitable interests competing against subsequent legal interests. So prior equity against subsequent legal interest. Secondly, prior legal interests against prior legal interests against subsequent equitable interests, and prior equitable interests against subsequent equitable interests. So we've basically got a prior equity or a prior equitable interest against a subsequent legal interest. That's the first one. Right, the second one is a prior legal interest against a subsequent equitable interest. And then the third one is basically the competition of equitable interests. So prior equitable interest against a subsequent equitable interest. And what we're trying to work out is what is the framework of rules that the general law has developed to govern these competing interest scenarios. Okay, and what's going on in this area is that really we've got where there is an equitable interest at play, then the court or the framework of rules that's actually trying to determine the priority question is really a court of equity, because it's a court of equity that is recognising the equitable interest. Yeah. And the court of equity will apply its approach to examining the interest holder, the conduct of the interest holder, and what would justify one interest taking priority over the other. I mean, ordinarily, common sense would dictate that time should, be the order of the day, as it were. But where the interests are different, so one is legal, one is equitable, normally, again, the principle is that legal interests prevail over equitable interests, or law prevails over equity. But will there be justifications for why that should not be the case? Why a later equity should possibly prevail over an earlier legal interest? Where there is a competition between equitable interests, then is it just a case of the time in terms of when the interest was created prevails in terms of determining the competition, or is it something else that is considered? And what is it that a court of equity, before we just launch into the questions, what is it that a court of equity concerns itself with primarily?
in terms of some of the cliches, such as one who does equity or to seek equity, you must do equity, or you must come with clean hands? Or are you talking about more the sort of the principle of justice, that sort of an equitable justice? And I don't know how to rephrase that.
Let me just say one thing on, and thanks for both of that comment, Grant. But let me just say something here, and I'm going to refer back to a case shortly to support what I've got to say in a good lawyer's method. But you know, these maxims, which is what you've referred to first, Grant, equitable maxims, are really just shorthand expressions that tend to have helped the Court of Equity, you know, firstly the Chancellor, then the Chancery Courts, and then equity courts exercising equitable jurisdiction in Australia, and then finally, after fusion, the fact that the Superior Court, you know, Queensland Supreme Court, Court of Appeal, and High Court of Australia can exercise equitable jurisdiction in common law and equity and choose which framework of law is most appropriate given, you know, the nature of the arguments presented and what's being sought by the parties and so on and so forth. But those maxims are just really shorthand expressions of what the court and what equity is really about, okay? So, no, not really interested in those sort of shorthand expressions, just, you know, trotting those out. It's more the second thing. Just can you repeat the second thing that you said, Grant?
That justice for parties that isn't otherwise served by, I guess, the black letter rule of law.
Yeah. Now, in terms of that, right, it is seeking, you know, Court of Equity is seeking to do justice. But what does the Court of Equity look to, you know, in terms of trying to decide that, where, in this case, we've got a competition of interests. So it's looking to the interest holders, whether they be individuals, whether they be companies, whatever, looking to the interest holder. What is it examining to try and determine what should be the outcome? In the ends of justice, yes, but what are they focusing on?
Do you mean are they looking at the conduct and behaviour of the parties?
Very good, thank you, Lisa. The conduct and the behaviour, yes. And what in particular about the characteristics of that conduct and behaviour are they primarily concerned about?
Negligence or misrepresentation or fraud?
No.
They're looking at that? No.
Ethical behaviour?
That's better. It starts with a C.
Conscionable behaviour?
That's better still. They are really, at the end of the day, Court of Equity is looking at the conscience of the interest holder and how that conscience is manifested through conduct and behaviour and decisions of the interest holder, right? Now, the interest holder can be an individual. The interesting thing is that, you know, the way that courts analyse issues that come before them, you almost sometimes think that they're always considering the conduct and behaviour or the decisions of an individual, when the truth is that for legal purposes, very often they're considering the conduct and behaviour and decisions of a corporate entity, which of course is made up of people, but it's a corporate entity and it has, you know, it is a legal person in its own right, or maybe a government of the day, represented in however the government of the day can be represented as a person in legal proceedings. So it's not always just an individual person, but the way the court proceeds often gives the appearance that it is a person. Certainly the earlier English decisions, like Pilcher's case that I've already referred to back in the 19th century and in the early 20th century, very often we were looking at conflicts between individuals. But in the modern period, we often find, like the AG CQ case, two mortgagees, but they're certainly not individuals. They're actually very large corporations who are mortgagees fighting over the rights to a unit of land in Mackay, as you do. Of course, the rationale behind why they're having such a fight and taking it all the way to the High Court is because there must be something pretty significant that's of interest to them. I don't mean equitable interest at this point, but I mean in a general sense financially and in terms of their business, their commercial business, that would lead them to take the matter as far as they have and expend the resources and the finance to support that claim. We can't ever move away from the realities of how the law is functioning. We can delve into the detail and the minutiae of the principles and the rules and how they are developed and evolved and how they work in particular situations. But the reality is today that often High Court disputes are taken by governments or by large corporations because a High Court appeal that can be 6, 7, 8 years, 10 years away from when the original dispute arose, to bankroll it, you can be looking at, upwards to $6 or $7 million. It's not inexpensive. That raises a whole lot of questions beyond what we can look at in terms of access to justice and whatever. But all I'm saying is don't forget the realities, don't forget the environment within which these disputes actually surface. Okay, so conduct, behaviour, decisions, the conscience of the interest holder and how that is important in understanding whether the conduct, behaviour or decisions should justify some rearrangement of the priority of interests. That's really what's going on here. And it further makes a difference whether the interest holder is a legal interest holder or an equitable interest holder, or whether we have two equitable interest holders, and whether we have an earlier equity and a later legal, an earlier equity and a later legal interest, because law normally takes priority over equity. But what would justify an early equity being able to take priority, for example? Okay. But again, as I emphasised earlier, we're looking at how this is governed under the general law. Yeah? All right, so let's move to the tutorial problems, starting on page 34 of the notes. Let's look at part A, problem 12, part A. What is the underlying rationale of the doctrine that an equitable interest will be defeated by a purchaser of a legal interest in circumstances where the latter is bona fide for value and without notice of the equitable interest? Who'd like to have a go at that?
It's Grant.
Yeah. Please.
I sort of looked at this from two angles. One was, I guess, the technical textbook answer, giving weight to protect an innocent purchaser who acts in good faith, does the right thing. There are always going to be two innocent parties, or often there's going to be two innocent parties, and the court has to give weight sort of to one. And what developed over time, this is now where to me goes to the deeper level, isn't it really about protecting ultimately the economic interests of property and the property market, so that if purchasers can't be assured of obtaining good title and clean title and clear title, wouldn't that negatively impact property per se, real property? So I was sort of thinking that there's the Pilcher case, which defines the process, the legal process. But then when you're talking about the underlying doctrine, isn't that really to protect the property market?
Anyone, any thoughts on that? On either of the points that Grant's raised. Grant's raised issues that touch the legal matrix or the legal framework, and then the, if you like, commercial reality, I suppose. All mics remain muted. waiting for I wonder what. Okay, look, that's thanks for that, Grant. I think that's an interesting response and an insightful response, and that's what I would like to encourage all of you to do. I mean, I think that firstly you need to grasp the framework of how the law has gone about differentiating the interests and which one takes priority at the end of the day. And we'll come to that just momentarily. But the underlying commercial reality, the underlying rationale for creating outcomes that are sustainable, that make sense and allow transactions to proceed with a degree of certainty and reliability is absolutely a factor that drives the court's decision-making and the evolution of rules. I use that word evolution of rules and principles. As we'll see in a couple of weeks' time, often you can get a radical judge, for example, that might suggest that we should basically start, that all this is too complicated and society's moved on, and you know, I think we need to basically start again from fresh. Michael Kirby sometimes was a bit like that. Lionel Murphy was a bit like that. We'll see one of his judgments in a couple of weeks' time. The great bulk of judges, even those judges who have a concern for the law being responsive to social and political change, find that very difficult. And what is the more commended approach mostly is to fashion and shape and reshape the framework as society evolves and as the circumstances and the social conditions and the political conditions and what's morally acceptable or not acceptable, it changes over time. So that we don't actually do away, as we were talking about it on Tuesday's class, we don't actually cut off history, but we find a way to respond to it that's relevant today. I was just listening, I don't know if any of you, just as a side issue, to the PBS Public News Hour from the United States. It's on SBS late in the afternoons for an hour. And there's a decision of the US Supreme Court, which has just been handed down with regard to, again, the vexed issue in the US about race and segregation in schools and so on and so forth. And just a side point, which just touches on what I was just linked to what I was just saying, Justice Sotomayor has come out with the point that we cannot cut off history in that case in the context of race, but we can't forget everything that's informed the framework that we have. So just as the framework of principle and rules has evolved from Pilcher's case in 1872 through to 2014 in Queensland, the nature of business and commercial reality and how we deal with each other and how we live has changed, and we have to adapt to that as well. Right? Sometimes the law does that more successfully than at other times. Now, Grant mentioned in part of his response referred to the purchaser. Now, this first question is getting you to focus on that idea of what is the significance if in fact the legal interest holder is a purchaser. I mean, how else could, I mean, a legal interest holder doesn't necessarily have to be a purchaser. What else could there be?
A leaseholder?
It could be a leaseholder survey. Could. But that's not what I'm looking for. The purchaser, what is the purchaser providing? When you buy something. Sorry?
Consideration.
Precisely. So the purchase, when you purchase something, you're a buyer. I mean, we tend to use purchaser, the phrase or nomenclature vendor and purchaser in land transactions, but essentially they're a buyer. And they're providing value. Consideration, of course, is value for the transaction. Right? The law historically places that person in a different category to a person who acquires an interest when no value is passed. What do we call that sort of a transaction, or that sort of a person? They're not a purchaser. What are they?
An adverse possessor?
Oh. They are a volunteer. Now, you might think, oh, how can they be a volunteer? Maybe they work for a community organisation. No. A volunteer means that they have not provided any value. In other words, it's a voluntary transaction. It's a gift.
Gratuitous? Yeah.
Right. But they are in the circumstances of being described legally as a volunteer. Now, equity takes a different view about protecting or dealing with a volunteer who has provided no value to a purchaser. Notice the phrase here is a purchaser of a legal interest in the circumstances where that legal interest holder is bona fide for value and without notice of the equitable interest. Now, there are three dimensions there. We're looking at the value, so that this idea of providing value or consideration, if you like, as Grant's mentioned, for the transfer. But there's also two other aspects there. One is that this legal interest holder has acted in a bona fide way. What does that mean?
He's acted in good faith.
Acted in good faith. What do we look to examine the idea of good faith?
His conduct.
Quite so.
In this particular question, is it whether or not they had notice of the equitable interest?
We'll get to that, because the notice aspect is the third component that we need to look at, okay? And we'll get to that, so it's important, Nick. But there are three aspects here. First of all, we need to have a purchaser, a person purchasing, buying the property for value, so valuable consideration, okay? And remember that value, of course, in this context, if you go back to your contract law studies, it has to be, it's not what the law considers to be a value, but it's of value to the person, the promisor, promisee, and so forth, right? So that if it's value as between the parties, well, that's good enough. It doesn't have to be what the court determines to be of necessary value, right? It could be peppercorn amount, for example, but, if it's a value then to the parties, then that's good enough. But being where there is value, when we can specify there has been value, then that is a different scenario to no value or a gift or a voluntary transfer. Bona fide, that's focusing on the it's not just focusing on the conduct, but it's focusing on what characteristics of the conduct. Oh, it was mentioned, I think, by Lisa. Good faith, right? Good faith. How would we? What other ways can we explain good faith?
That he's acted honestly.
Yes, honestly.
Has acted.
Honestly, yes. But again, courts of equity will go back and use this C word. What's the C word?
They've acted in good conscience.
Conscience.
So they've taken reasonable steps to protect themselves they're not sort of blindly sort of exposing themselves to risk. They have to take reasonable measures. And
that's good, but the point is, notice the language we're using: conscience, reasonable, what should be done, what's appropriate to be done in all the circumstances. In terms of a land transaction, it may involve, for example, what should have been done according to good conveyancing practice with regard to the relevant legal documents. And I don't expect you to know all of what's required there. That's would be reaching too far. But within conveyancing practice and protocols, there are certain documents that underpin the transaction. And have you done all that you could have done with respect to those documents that reflect my legal interest, for example? Okay. We'll get to notice shortly. Okay. We need to look a bit more closely at that. But the bona fide, so don't forget that this is in the context of saying whether the legal interest holder has to recognise the right of the equitable interest holder. But if the legal interest holder has taken for value and has taken bona fide with best intentions, in good conscience, and then without notice of the equitable interest, then the legal interest holder will not be bound by that equitable interest. Now the question is, this idea of notice raises interesting dimensions. What do we mean by notice?
The types of notice, or
what do we mean by the word
notice itself?
What do we mean by that? Notice means what?
That the purchaser has done everything reasonably expected of him to become aware of.
That's the word, awareness. So notice is you're aware of this other interest, this equitable interest, right? Now then the question arises, and I think Grant was going to touch on this, that is, what types of notice does the law recognise? Or what categories of notice is possible?
Is that the actual
notice?
Right?
Constructive.
What do we mean by actual notice? What's an example?
An example might be a document that spells out the equitable interest that is on that property. Exactly.
So the and equitable interests will not necessarily be recorded on title documents, but there is something there that gives you actual notice. It may have even been a communication. It may have been a conversation that persons are prepared to give evidence about at the end of the day, and so on and so forth. So actually aware, basically, this idea of notice, actually aware. The other, of course, is, I think, which you've already mentioned, is constructive notice. What does that mean?
Is constructive obtainable?
The best way to explain it is it's deemed. You're deemed to be aware of this interest, but the idea of the deeming has, in this context, gives, it works itself out in terms of the obligations of the interest holder, in this case the legal interest holder. And with regard to a land transaction, the constructive notice works itself out in terms of two different aspects. And one is in relation to the land itself, so a duty to inspect the land, to have a look at it, to be aware of the land and its circumstances and what's affecting it and so on and so forth. And the other is with regard to title documents. Now, one of the cases that was in the set reading tossed up the idea of the tenancy agreement. Do you remember the Smith and Jones case?
Is that the one where he bought the farm at an auction? Is that one?
Say again?
Is that the one, sorry, that Jones bought a farm at an auction?
That's the one.
That's the
Smith
one?
and Jones, page 133 of your casebook. Okay. It's, again, you know, a 1954 English case. So basically the property was bought at an auction, but it was bought, there was a lease, subject to a lease, and there was an examination of the lease, and then when there was a conversation about the nature of the lease, there was some disagreement then about the terms of the lease, whether what was in the agreement was actually what was the terms of the lease, or in fact the lessee said, no, actually it's something else. And what did the court say about that at the end of the day?
I think the court, from memory, said that the fact that they did see the physical lease, the document, that was sufficient, and it wasn't reasonable to expect them to, for example, go and talk to the leasee to say, is the lease actually different to what this document says?
That's right, but even more than that, that the purchaser can rely on the terms of the lease agreement. It's what's in the lease agreement is what one would expect to be the terms of the lease. You would not then, you know, it would not be expected that you could have a conversation about the nature of what constituted the lease apart from the lease agreement. Okay, so that Justice Upjohn said, and this is I've referred you to this at page 17 of my notes. When a purchaser examines a lease agreement, he is bound to assume that it does correctly state the relationship between landlord and tenant. Just imagine if it was otherwise, particularly in the modern period where tenancy agreements under legislation are standard form. Right? Even commercial leases are not standard form necessarily. They can vary from case to case. But there is a form on which, like, I mean, clauses and provisions within commercial leases that are fair, you know, usual. There can be special conditions, of course, but fairly usual. So if you couldn't rely on what's in the actual document, but only in what people thought was the lease, this would create a huge degree of uncertainty. So this goes back to I think Grant's earlier point about, you know, the court's always mindful that what is the consequence of holding in one way as opposed to the other. It's ever mindful of reality and impact and consequence, as well as making sure that we have an evolving legal framework that's fairly certain and fairly dependable, but in my view has within it flexibility. That's probably more true of equity than it is of common law, but even the common law, you know, it's not absolutely set in concrete, and you know, it can't be, otherwise it would be would become ossified. So we've got these two bases, and I refer to this on page 17 and following in the notes with regard to the differentiation of the different categories of notice, and then within constructive notice, what are the obligations there with respect to what amounts to that notice, So, you know, it's not that you, even if you don't have actual notice, the law is not saying that you can sit on your hands and do nothing. The law will also recognise constructive notice by looking at the totality of the situation. The point at the end of the day here is that if we have a legal interest holder which meets this benchmark of bona fide for value and without notice of the equitable interest, then that interest holder's interest will prevail and it will not be impacted by the equitable interest. But the question is, determining those features is not always a straightforward process. And that's really the outcome. All right, let's move on to 12B if we can, please.
I'm just reading my notes, trying to refresh and remember. In my notes, I've got that a restrictive covenant is enforceable against an adverse possessor of land. And the case that related to was Nisbet and Potts. However, my interpretation of that was that the adverse possession that related to did not satisfy the statutory period where they would attain, you know, title in fee simple, you know, good against all the world. So a point that I was unclear of with this is that with adverse possession, although on the second part, following the process of who was it? D, assuming on the presumption that he had done title checks and had done the right thing and acted in good faith, that he would be entitled or not bound by the equitable interest. What I wasn't clear on and what I couldn't work out was if the adverse possession, because once they obtain title that is good against the rest of the world through their adverse possession having satisfied the statutory period, if they have title that is good against all the world, it doesn't qualify with those earlier points in terms of the adverse possessor hasn't paid consideration, but he's obtained good title against the world. So that's where I couldn't sort of, you know, from the cases, I couldn't work out whether the equitable title had already virtually been extinguished at that point once he obtained good title. That's where I got stuck on that problem.
It's a good point to get stuck, in my view. Before I chip in, would someone else like to add to that or challenge what Grant said or qualify or?
It's Nick here. I was along the same kind of thought pattern. Obviously, B has an equitable interest in the property. C comes into an adverse possession of the property, therefore obtaining a legal interest. I didn't really consider whether or not B's equitable interest is just discharged at that point. I'm more focused on, you know, D's legal interest.
In terms of time,
who we're advising.
In terms of time, which category of competing interests under the three categories in this topic does this scenario fall into? Remember the three that we've got? The three that we've got have prior equitable and later legal, prior legal and later equitable, and competing equitable.
So it's prior equitable, later legal.
Precisely.
With the adverse.
If we're advising D.
We get to the adverse. You've both Grant and Nick. You've indicated that aspect of the adverse possession, which is a critical part of this information in this scenario, and put there deliberately. We'll get to that in a moment. But in legal problem solving, it's absolutely critical to unpack the information and then reorganise it. That can be done, in my view, most effectively and efficiently by constructing a diagram. So pulling it apart, identifying who the characters are, identifying what their legal status is or what interest they hold is, and then construct a diagram that links them together. The other thing that's very important, particularly in a priorities question, but you'll find increasingly in property law problem-based scenarios generally, a timeline of events. Very general in this case, you don't actually have dates and times, but you do know that one interest was recognised first, there was a second interest, and so on and so forth. Just getting all that clarified, and then asking yourself, what is this question really about? Is this a priorities question? Is it a question about restrictive covenants and how they operate? Okay. It's unavoidable, as I was mentioning earlier in the class, that concepts at times will arise or be thrown in that firstly either aren't really germane to what we're looking at, or they relate to some part of the area of law that we haven't had a chance to yet fully investigate. Right? Notice here that the facts say that enters into the restrictive covenant with B, okay, and then it says the effect of the transaction is to give B an equitable interest in Blackacre. So the critical conclusion here from that part of the fact scenario is not the fact that you need to concern yourself overly with the fact with it being a restrictive covenant, because we don't really fully understand what that is at the moment, but that the consequence is that it gives rise to an equitable interest. And when certainly on the facts, it would appear that we have a first in terms of the time sequence, we have an equitable interest coming into existence first. Now, we then have the C dispossessing A and remaining in adverse possession. So now we get to this adverse possession point. And this comes back to Grant's comment or contribution about, well, what does adverse possession achieve here in terms of the competition of interests? Certainly, the type of interest we seem to have here, and I think as Nick indicated as well, is it's a legal interest. It's not an equitable interest. Yeah, but we go back to what the law has recognised, what equity has recognised in terms of how a legal interest is affected by an earlier equitable interest or not, then we must return to this idea of bona fide, for value, and without notice. Yeah? How does an adverse possessor meet that criteria?
An adverse possessor doesn't. It's not a bona fide purchase. And that to me was clear in the sense that adverse possession, prior to it becoming ownership, it's not a bona fide possession. So to me, it's very easy to work that one out. But because he's achieved and reached the statutory period where he's obtained good title in fee simple, he can
transfer that, can't he?
Yes, he can.
Yes, exactly. So he can transfer his legal interest, but it's not an interest that he has acquired as a purchaser for value. And a court of equity will view the circumstances of that legal interest holder differently to a legal interest holder who has purchased for value. That's the critical difference here. Okay, this is a good, and this is the reason I tossed up this question, because it's, without being overly complicated, it is a nice way of linking back to a couple of the earlier concepts that we've touched on earlier in the course and showing how they can be relevant, bringing in an idea from, you know, the future in terms of land law, but still an example, a good example of an equitable interest, but trying to get you to unpack that in a way to focus on the particular area of the law that you need to concern yourself with to resolve this issue, because this is essentially a priorities question, and it is about a priority between an earlier equitable interest and a later legal interest. And the question is, will that later legal interest have to acknowledge and be affected by the earlier equitable interest or not? And what do the rules that have been developed by equity determine in terms of that? And as we've seen, because D does not find themselves in a situation of where they have taken for value from C, then and so C was the adverse possessor, then it doesn't meet the requirements. And if we think about the Pilcher and Rawlins case, which we looked at earlier, then the requirements that was recognised in Pilcher and Rawlins haven't been met. So the outcome, what is the outcome for D?
Can I just go back one step?
Yep.
Where understanding in terms of C, B and C, and it not being a bona fide purchase, but C does have a legal title to the property.
Yep.
They're not the bona fide purchaser, but then if D, I don't understand how D could not be they have to be a bona fide purchaser if they purchased from a legal title holder in good faith, presuming that they have done their checks and title checks and satisfied themselves and they've acted in good conscience.
But the question
I don't understand why D is not then a bona fide purchaser.
Because it's not a question, that's not the issue at that point. It's a question of the title or the interest. It's a question of the nature of the interest that D actually acquires. And in fact, because of the way in which C had an interest in the property, that then means that what D actually gets is an encumbered interest. D does get the legal interest, but it is encumbered by the earlier equitable interest, not free of it.
So this goes back to you can't sell what you don't have. In
part, yes. Well, you can't. Yeah, that's right. In this case, you can't transfer more than you have, and the adverse possessor does not have unencumbered title. The adverse possessor, because of how they have acquired their legal interest, according to the way that equity has determined whether the earlier equity should be recognised or not, means that that equitable interest is preserved and encumbers the property. What's the rationale for that? Let's go back to your point earlier, Grant. The rationale is that the equitable interest can only be displaced and not recognised as affecting the property if we have a person that's purchased for value and in good faith. That's what equity has said will allow the legal interest holder not to be encumbered by the earlier equitable interest. And where we don't have that, then the equitable interest will encumber that legal interest. Now, one of the points that I make at the beginning of this topic is one of the reasons that we need to cover this topic, even though it deals with the general law priorities, is because the mechanics of how we deal with these priority questions under the general law does have relevance under the Torrens system. And we're going to see in time, when you undertake land law, how that works. But for example, under the Torrens system, we will discover that it's the act of registration that creates the ordering of priorities. But what if an interest has not been registered? That then gives rise to an equitable interest. What if, for example, we have an interest which is registrable? I don't want to go too far into this, but I'll just mention it. An interest which is registrable but remains unregistered. How does that compete with an interest which is not able to be registered at all, but which is otherwise recognised by equity? It's because of these types of issues that the general law priorities framework is still important to help us better understand how to resolve priority questions for Torrens title parcels of land. Because at the end of the day, even though we have a system in place there to make things more efficient and more straightforward and more certain and more secure, human nature and practice being as it is, all of the features of those systems are not always deployed. There was a practice, as we'll discover again in land law, at one time of banks as mortgagees not registering their interest, but just depositing the relevant documentation in their vaults. That was a commercial practice of banks, and then that caused issues, and so there was a change in banking practice. But there are these foibles, either as a result of commercial practice or as a result of just human foibles. I can't put it any higher or lower than that in terms of how people function and operate, that often give rise to issues and complexities in terms of how the law has to try and unpack these problems and tensions. All right, thank you, gentlemen, for that, and Lisa, if she's still with us. No, I think she's gone. All right, let's move on to problem 13, if we can.
I'm back.
Oh, are you? Okay, sorry. Good, excellent.
No, I went over there and only one person turned up for evidence, so Anthony finished it early.
Don't tell me that property has trumped evidence. I can't believe that.
There you go.
Welcome back anyway. So problem 13, what is required before a prior equitable interest will be postponed to a later equitable interest? What particular characteristics of conduct will be critical? Are some more important than others? Well, we don't even have to decide which of the three categories of conflicts or priorities we're dealing with here. We're dealing with the competition between two equitable interests. Who'd like to have a stab at this one?
I'll have a go.
Thank you.
Where there are two competing equitable interests, Rice v. Rice comes to mind, but that's
Rice and
treated,
Rice.
Rice and Rice, but that's treated as a last resort because the courts will look at the conduct and of the parties and their intentions and whether they've acted in good faith and the manner of the acquisition to determine who has the better equity.
Yes. Thank you for that. Anyone else would like to add in? So we've had Lisa refer us to Rice and Rice, which is an early English equitable case and the judgment of Vice-Chancellor Kindersley, which has been referred to many times and is incorporated into the AG CQ case. Anyone else?
I've actually got that same case down as the time, all being equal, if both parties sort of have the same sort of equivalency of equity, then that's where time does come into it, and then the earlier equitable interest will trump or prevail over the later equitable interest.
And which case are you using as support for that proposition, Grant?
In my notes, I put down Rice and Rice for that one.
Mm-hmm.
But now, with what I'm hearing, I think I've written down the wrong case.
Rice and Rice is a bit old, isn't it?
It's a very old case.
It's an old case. Fiona, yes.
What's that? Oh, are we looking for newer ones? What about the Cash Resources Australia one?
Which one is that?
Cash Resources Australia versus BT Securities. No?
Yes, possibly. I'm really, I mean, though there are some key cases that are referred to in the AGCQ judgment that really track us through the waxing and waning of how we deal with this competition of equitable interests. So yes, we've got the Rice and Rice decision, which is a significant case and still significant in this area of the law. And it has saying, well, we need to look at the equities. Have we got equities on the same footing? Have we got different equities? Do we think about that? Are we overly dependent on or focused on the time when the equitable interest or the equity arose? Is that the determining factor? And the Rice and Rice case says, well, priority of time is a ground of is the ground of preference of last resort that we go to last. We don't look at that in the first instance, but I think, as Lisa mentioned, we look at the equities generally and the nature of those and whether they're otherwise equal. And one of the things that in that case was emphasised was that we're concerned with broad principles of justice. And how that gets implemented. And then we move forward to other cases, and in particular the High Court decisions of LATEC investments, and we'll look at that case again in land law, and also the Hyde and Reliance Finance case, another High Court decision. In the LATEC investments case, Kitto was emphasising this idea of how do we determine the better equities, and we look at the merits. Are they equal or unequal? And it's not just about the time ordering. But when we get to the Hyde and Reliance Finance case, a broader way of viewing this, more holistic way, more fundamental way, I think, of is being advocated, so that Mason and Dean, there are emphasising we need to think about a general flexible principle, focusing on the conduct of the earlier interest, trying to seek to do fairness and justice. And is there any basis, by thinking about these ideas, that the earlier interest should be postponed to the later interest? And then, you know, we have that formulation on page 29 of my notes from that case, where Mason and Dean say that the overriding question is, whose is the better equity, bearing in mind the conduct of both parties, the question of any negligence on the part of a prior claimant, the effect of any representation as possibly raising an estoppel, or whether it can be said that the conduct of the first or prior owner has enabled such a representation to be made. In summing up, there was this idea that we can look at meritorious and unmeritorious or disentitling conduct. So it's a broad examination of the conduct of the parties, and mostly of the conduct of the earlier interest holder, to see whether that should be displaced as being the first in time. The fact of being first in time doesn't determine the outcome, but it is a factor to be considered if the equities are otherwise equivalent. If they are not, and the conduct and the behaviour is otherwise makes these equities equivalent, then the timing rule will govern. But otherwise, as I mentioned at the outset of this class, the concentrated focus is on the conduct and the behaviour of the interest holder, and in particular of the interest holder first in time, which would justify it being displaced to a later interest holder where they are both of the same type of interest, that is, both equitable interests. But the question then arises, of course, what type of conduct or behaviour of the earlier equitable interest holder will be considered sufficient to displace their interest in terms of a priority with a later equitable interest? What is the law, or what has the court said about that?
Wasn't that where if they didn't take sufficient or have sufficient means to protect their interests, if they were negligent in protecting their interests? And
so is negligence enough? Can we look at gradations of negligence? Is there something more unmeritorious, if you like, if I can use that form of expression, than negligence, something more serious than negligence?
Fraud.
Yes, good. But naming it is easy. Knowing it is another question. And as we'll discover again later in the course a bit, and also in land law, we have to distinguish between the general understanding, popular understanding of fraud, and what it means within specific circumstances in law. And even then, we can differentiate between, for example, fraud as known within legislation on the one hand, and then we might also talk about, for example, equitable fraud as well, as another type of fraud, for instance. So we can talk about this idea of fraud, we can talk about negligence, we can talk about, reprehensible conduct, going to starting to touch this idea of conscience and appropriate behaviour in terms of the interest holder and the way they should be conducting themselves and so on and so forth. And we don't, at the end of the day, these are descriptors that help to guide us in what will amount to displacing the earlier interest holder. And these are factors for you to consider, but there is no universal answer here. You have to look at the total facts of the situation. You have to think about these ways of characterising conduct or decision-making or behaviour, and then by the application of that against the background of the types of factual situations that have surfaced in the cases, what should be the outcome that commends itself in the situation that you're facing? And how can you support that with legal authority, with the most robust, currently relevant legal authority at your disposal from the materials that we've and I've asked you to consider and go through. And, the answer, there's not necessarily a universal answer here to questions of this nature. It really ultimately will depend on how you characterise the behaviour and conduct against those standards. But you have to ask yourself, which of those is necessary? So, is just being negligent enough? Do we need fraud? What about if it's negligence involving also, for example, dealing with land documents, not adequately securing those documents, not adequately doing, and if we move ahead into the context of a Torrens title type scenario, not doing all that is necessary to put the documents in order so that they can be registered ultimately, and we'll see the impact of that later when we look into these matters in land law. So it's a question to be applied to the particular facts, and it's not something to which we can give a universal answer, but there are particular characteristics that we can look to, and then we have to ask how those characteristics are satisfied, basically in light of the case law and in the context of the particular facts at hand. But remember, at the end of the day, that equity, go back to those broad ideas of what equity is seeking to achieve and the methods whereby it's seeking to achieve it, and the consequences of, for example, being prepared to displace an equitable interest, or the consequences of burdening or encumbering a legal interest with an equity or an equitable interest. So these implications and consequences in reality and in terms of commercial life are not something that is irrelevant. They're very relevant, okay? But Court of Equity is also concerned about the sense of making sure that people do what they should be doing in a proper way in conducting their affairs and in the transactions they're entering into. And it has to find a way of coordinating a range of interests that are often don't sit easily together and are in competition with each other. And there we are. We have about 10 minutes, people. I'm happy to take any questions, issues, whatever. Oh, just one little thing before we finish. Just remember that with regard to general law interests, I didn't put a question on this, but it's at the end of the notes. There is, of course, the deeds registration system, which is now dealt with under sections 241 to 249 of the Property Law Act, Queensland. And basically, the deeds registration system was a way of allowing deeds to be registered so that there could be a place where these legal documents, the deeds, were recorded. But it's of critical importance to remember that the deeds registration system does not, unlike the Torrens system, which is also in Queensland incorporated within the Property Law Act, but those provisions with regard to general law land, where deeds and land title documents have been lodged as part of the deeds registration process, that process does not give rise to the legal interest or to the interest in the land. It is the deed that still does that. All the deeds registration system does under those sections of the PLA is to actually provide a place where those interests can be recorded and people can see them, but it doesn't create them in the way that the provisions of the PLA which deal with Torrens title does. As we will see when we get to Torrens title land, that it is the act of registration that creates the interest and confers the indefeasibility of title, which is the quintessentially defining characteristic of Torrens title. So when you hold your certificate of title and you read the contents therein as the registered proprietor, be ever aware, either now or when this may occur in your life, that you have that characteristic of ownership that is defined as indefeasibility. And we will investigate that at length in land law, because it's a very important idea. All right, that was the last point that I just wanted to make. But so we've got a few more minutes, about 5 more minutes, if anyone would like to raise any further points or questions. Silence is golden. I think we're all exhausted, I dare say. Maybe time to go back to evidence, Lisa.
I think time to call it a night.
Yeah, well, indeed, ma'am. Indeed. I was being a bit facetious. It's too late in the day and too late in the evening to be facetious after a class on priorities, that's for sure. Just a couple of words again about the quiz. So it'll be available from late in the afternoon on Saturday. 3 questions covering topic 4, topic 5, and this wonderful topic of priorities. Mixture again of discussion type or essay type questions and problem solving questions. I'll leave it to you to try and work out which topics are more commendable as problem solving type questions as opposed to other types of questions. And each question will be worth 5 marks, and so expect something a little bit more stretching than the first quiz. Although some of your colleagues suggested that the first quiz was a bit stretching too, but there we go. You're in for a bit of a elasticity in my courses. You know, that's part of the deal. Yeah. So,
can I ask? Sorry.
Yes, please.
With the
quiz. Yes.
Yeah, sorry. With the quiz, are we able to like type it in like a word and then copy and paste it in, or do we have to actually type it directly into the space provided?
Look, that's a good question, and thank you for that. There was issues with some people finding it's difficult to cut and paste into the Moodle. I suppose, and I was giving some thought to whether to change the matrix in Moodle for this time, but then I decided no, it's best to leave things the same so there's not any further confusion, because I think we don't certainly need further confusion at this stage, of course. So I'm going to leave the matrix the same. What I mean by that is, that you can make multiple attempts and things like that. But one thing I would say, and for both of all of you that are here and also for anyone listening to the recording, that when I was grading the first quiz, it is sometimes a little bit confusing where there are multiple attempts that have been saved, and I've got to work out which is the final attempt. What might be a best way to do it is to take the questions and to maybe draft up answers offline and then just type in those answers into the quiz boxes. I think there is a way of getting the information across, but just the cutting and pasting sometimes causes some technical problems. And there were a few students, I think, had some technical problems. But certainly you can make multiple attempts. That's, you know, you will be able to do that. And so long as you save your attempt and submit the attempt, you can then come back and make a further attempt and build on that. Yeah, so that's, but there were some technical issues in just a straight cut and paste, Fiona. Yeah, just the way Moodle works, unfortunately. Yeah.
Okay, thank you.
Michael, just a question on the first quiz. Although we've got grades, so we know sort of how we scored, will there be any sort of feedback on the first quiz? So we sort of know where, sort of, you know, we got the grades on those questions. Because I know the total grade for the quiz, but I don't know whether there were specific questions that I did better in or not so well in.
Look, you know, I'm happy. Tomorrow I will endeavour to load up some general response to the questions, to advice in terms of what I was looking for, and also, you know, the general performance. And if still you want some further feedback, individual feedback, then I'm very happy to deal with individual students on that basis.
Okay, thank you.
Yep.
Sorry, what about referencing for this quiz? Do we just put them in brackets?
Just, you know, you can do it in text, you can do it as footnotes. I just need you to support your points with case law and or legislation. That's absolutely critical.
Yeah.
And please just, you know, give me the reference to the case as is appropriate, and you can have that in the text of your answer. You can have it as a footnote, whatever works. I'm not really fussed about that for the purposes of the quiz, but I do need to see the law that's supporting. And just I need to see how you're saying it supports. Don't just tack it on to the end of your answers. How do you say that it supports the various points that you're seeking to make? Yeah.
Okay.
We might run out of time in a moment, I think, so I might call this to a halt. Thanks for joining this evening, people, and good luck with the quiz. Bye for now.
Thanks, Michael.
Thank you, Michael.
Thank you.
Thank you.
Bye, everyone.